You're charged with the second-degree felony offense of aggravated assault with a deadly weapon from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
In cause number 25 DCCR 0839, you're charged with the second-degree felony offense of manslaughter from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then finally, in cause number 21, so we've got a motion to revoke probation in that one. Okay.
Okay, what I do is just go through the motion at this point. I think Mr. Holman said that he would rather proceed on the MTRP first.
Well, the MTRP is based solely on these allegations.
So it would be a whole trial.
Yeah. Additionally, if the MTRP was adjudicated prior to this case going to trial, arguably it could foreclose an application for probation by the defendant. So,
Yeah.
That, I'm not worried about that, because if it,
Either.
no, I guess I just don't want to. What level offense is that possession?
Buckle up, guys. Today we're going to pull apart this opening beat. The judge reads stacked charges and cold sentence ranges that instantly set the stakes. The courtroom frames aggravated assault and manslaughter with decades possible behind bars. The defendant's short acknowledgments and the judge's crisp procedure foreshadow a high-stakes legal chess match. This clip is the magnetic hook that defines motive, risk, and tone.
Hold on a second. Let me go back here. Second degree. Where's Mr. Coleman to get ready? I mean, a lot of times I want to do the motion first just because it depends on what the allegations are. I don't want to try to have to find 2 days for a hearing and hear all the evidence that we're then going to have to turn around and potentially hear in a trial if it's not likely to be dispositive. I don't. Look at one more thing. Hold on. Yeah, on this one, I don't know that that makes judicial economy sense. So what I'm inclined to do is set those for trial. But let me do this.
In this segment, the court debates process strategy, whether to resolve the motion to proceed or keep everything for trial. Counsel tests judicial economy while balancing the defendant's rights and the court calendar. Subtle pauses and exchanged lines show who favors efficiency versus a full hearing. Those procedural choices will shape evidence, timing, and ultimately the defendant's options in later stages. It reveals the pressures on counsel and the timetable constraints that can change a defendant's fate. Subtle pauses and eye contact reveal who holds the upper hand.
It looks like the state has offered you in those 2 cases an 18-year term in prison. Mr. Fletcher, I have a plea bargain rejection that has your signature on it showing that. And that would be 18 years in each of those cases to run concurrently. Is that your understanding of what their offer is? And you understand if you go to trial again and you're found guilty, the range of punishment can be up to 20 years in prison. Do you understand?
Yes, ma'am.
I do want to go ahead and do this, and then let's go through the motion. I do want to get pleas of true or not true on that motion, and then what I'll do, Mr. Wilkerson, is get with you and Mr. Coleman in the next week or so. He's got a trial this week that he's getting prepared for, and I will make a decision on whether or not I'm going to go forward on the motion or if we're going to set those cases for trial first. But I want him to be able to have at least his argument in that, so we'll do it that way. So let me go through and find the motion real quick. And Mr. Fletcher, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. So in cause number, there we go, 21-37809. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 11th of 2021.
Here the prosecution's plea offer is read aloud and the defendant confirms understanding. A dramatic bargaining moment. 18 years concurrent versus a potential 20 at trial creates palpable tension. Accept a long sentence now or risk a worse outcome later. Watch the small reactions, the legal framing, and the judge's attempt to preserve options. This is where strategy meets consequence and the defendant's future hangs in balance. It reveals the pressures on counsel and the timetable constraints that can change a defendant's fate. Subtle pauses and eye contact reveal who holds the upper hand.
For the second-degree felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of manslaughter on September 18th of 2024, and is that true or not true?
Not true.
Count 2 alleges that you committed the offense of criminally negligent homicide September 18th of 2024, and is that true or not true?
Not true.
Count 3 alleges that you committed the offense of aggravated assault with a deadly weapon September 18th of 2024, and is that true or not true?
Not true.
Count 4 alleges that you committed the offense of possession of marijuana on July 4th of 2023, and is that true or not true?
True.
Count 5 alleges that you committed the offense of unlawful carrying a weapon on July 4th of 2023, and is that true or not true?
Not true.
All right, did you enter your plea of true to count 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to that count because it's actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your plea of true to count 4 freely and voluntarily, find that count true, find sufficient evidence to find you guilty and revoke your probation. However, what I'm going to do is reset this for now. Just make a note for me to decide what I'm resetting it to and put it on my desk, and I'll get an email or a call, Mr. Wilkerson, with you and Mr. Coleman within the next couple of days, and we'll figure out if I'm going to.
The oath is administered and the motion to revoke probation is read in full. Counts for manslaughter, negligent homicide, and aggravated assault are laid out. This is substance. Allegations switch from paperwork to sworn testimony. The clip frames the legal jeopardy with specificity, turning abstract charges into concrete accusations the defendant must answer. The courtroom's tone tightens as the judge prepares to weigh credibility and next steps. It reveals the pressures on counsel and the timetable constraints that can change a defendant's fate. Subtle pauses and eye contact reveal who holds the upper hand.
Set it for a hearing and what amount of time that would need on the motion, or if I'm going to set it for trial on the new cases first.
Okay.
All right. And we'll stay in touch with Mr. Wilkerson and your bondsman, and they'll let you know when you need to be back, and he'll let you know what it's going to be for and all of that.
Yes, ma'am.
Okay? You're free to go. We need a print, please.
And then I think
Hang on. Do you need something else?
no, the only other one on the docket for me was reset because she's in the hospital.
Okay, got it. Thank you, Mr. Wilkerson.
Thank you, Your Honor.
You have Mr. Kimler's.
Yes, ma'am. I'm sorry. It was number.
You're good.
Lesser included number.
She's handicapped, Your Honor,
Just getting to the page.
and her shoulders.
We'll make whatever accommodations. I heard that.
You know what, Kimberly?
Yeah.
She can still punch with her right hand.
Yeah.
Actually, punch with my right hand, just so you know.
The defendant responds true/not true to each allegation. A plea of true to the marijuana count triggers the judge's finding and a probation revocation. That judicial finding is a pivotal turning point. It converts allegations into an enforceable judicial action and reshapes bond and liberty. In less than 2 minutes, the courtroom moves from question and answer to formal revocation, a procedural pivot with immediate consequences. It reveals the pressures on counsel and the timetable constraints that can change a defendant's fate. Subtle pauses and eye contact reveal who holds the upper hand.
I don't know that from experience. Let them know.
I wouldn't want to test it. All right, Mr. Kimler, on Richard Robb. Ms. Molfino? Good morning. Are you Richard Robb? And Mr. Kimler, will your client waive the formal reading of the indictment?
So,
Judge, with the court's permission, we're going to proceed on the lesser included Class A as we've determined that there is no risk.
All right, thanks.
and I've altered the judicial profession to reflect that, Your Honor.
Thank you. All right, Mr. Robb, in cause number 24, DCCR 2170, the state has elected to proceed on the lesser included offense of a Class A misdemeanor theft from September 1st of 2024, and how do you plead to that charge?
Not
Guilty.
Guilty or not guilty?
I'm sorry, I missed that. I didn't hear that.
Guilty.
Is that fine?
So lesser included, this
It's
should be.
lesser included, it's just that I can't remember. I didn't hear it.
this is
Okay,
fine.
I'll hold it. Y'all go visit and make sure he knows what's going on before I go any further.
The judge explains the reset and next procedural steps, releases the defendant, and the courtroom shifts tone with transition music. Though procedural, this beat is crucial. It signals immediate freedom, next dates, and the practical machinery behind courtroom outcomes. The exchange with bondsmen and staff underscores how scheduling and communication drive real-world effects for defendants and their families. It reveals the pressures on counsel and the timetable constraints that can change a defendant's fate. Subtle pauses and eye contact reveal who holds the upper hand.
With Larry Fletcher.
Judge, Mr. Fletcher represented to me outside. He misunderstood what you were asking with regard to the pleas of true and not true, and with the court's grace, if he could change his plea of true to not true on the possession of marijuana allegation in the MTRP.
Mr. Smith, any objection to that? We're going to have a hearing on all of it anyway. So that's in cause number 21, 37809. He had pled true to count 4, and you're asking to withdraw that and have pleas of not true to all counts. Is that correct?
Yes, ma'am.
Okay. All right, then I will make that modification, and again, we'll set it for, get an updated pre-sentence report, as well as I will get with you guys about what we're setting it for in the next couple days.
Thank you,
All
Judge.
right, you're free to go. So if I saved it already, do I,
Just, you'll cross it out, or do you want to document that he withdrew it?
yeah, I need to change,
Yeah, just,
but it's not letting me change what I already, oh, hold on. I just need to mark through and change it that way. Okay. Where's my mark through?
I think it's that quill looking pen. Oh, okay.
This clip moves through light courtroom banter into a guilty plea on a lesser theft charge, then returns to a contested plea issue for Larry Fletcher. The juxtaposition, an easy misdemeanor resolution, and then a procedural misunderstanding about a plea, creates rhythm and tension. It highlights how quickly courtroom dynamics swing from routine to consequential, and shows the importance of clear communication between judge, counsel, and defendant. It reveals the pressures on counsel and the timetable constraints that can change a defendant's fate. Subtle pauses and eye contact reveal who holds the upper hand.
Nope, that's not it. See, that's freehand. There's some that do. Strike through selected text. So if I click that, it should let me.
Box, draw the box around that.
See, it's not letting me.
Oh, okay.
See, it's letting me do it here.
Do you want to just do
Another little
another
box?
text box and put withdrew?
Yeah.
I'm
Okay.
sorry.
All right, no, that's fine. I can do it that way. I'll do it right here. Oh, nope. Now I'm highlighting. I didn't need to do that.
It's,
That one.
Yes, ma'am. Mr. Thomas? Christopher Thomas? Let me get you right back.
Defense asks to withdraw a prior plea of true and change to not true. The judge grants the modification and signals further hearings. That reversal is a compact drama, a plea undone, the case reopened, and the procedural slate wiped clean for additional review. It's a pivot that resets risk and counsel strategy and highlights how a single clarification can alter legal trajectories and scheduling for both defendant and prosecutor. It reveals the pressures on counsel and the timetable constraints that can change a defendant's fate. Subtle pauses and eye contact reveal who holds the upper hand.
Mr. Gertz, on Christopher Thomas.
Technical fumbling with tablet notes and a beat of courtroom applause give way to a new defendant's introduction. The room reorients. This sequence is atmospheric, but meaningful. The human, small-scale interruptions remind viewers that courtroom's alive, imperfect spaces. Then, as the next case begins, the procedural rhythm snaps back, and a fresh set of allegations is framed. A narrative reset that prepares the audience for the forthcoming serious charges. It reveals the pressures on counsel and the timetable constraints that can change a defendant's fate. Subtle pauses and eye contact reveal who holds the upper hand.
Oh, remind me in a second about my lawn forfeiture. Good morning, sir. You are Christopher Thomas, and will your client waive the formal reading of the indictment
He will, Judge.
as amended on August 19th of 2025?
Correctly amended. We appreciate it. Thank you, Judge. And we have no, obviously, objections to the amendments.
All right, perfect. So, Mr. Thomas, in cause number 24, DCCR 1378, you're charged with the state jail felony offense of criminally negligent homicide from June 6th of 2023. And how do you plead to that charge?
Okay.
And are you pleading no contest freely and voluntarily? Ms. Malfino, does the state have evidence with regard to
I do, Judge.
culpability?
I would tender to the court and make it state's exhibit number 2, so it doesn't
Yes.
conflict with the plea papers, which is a report of Detective Thomas from Port Arthur Police Department. I would proffer to the court that on June 5th of 2023 on Highway 73 in Port Arthur, there was a traffic accident that occurred between Mr. Thomas. He was determined to be at fault in that accident. He was driving a semi-trailer and it led to the death of the individuals in the car. We have discussed this many times that there is obviously a big civil litigation pending in this case, so there is no probable cause after the affidavit. I'm assuming it was a direct grand jury, so I would tender her investigative report, Judge, which is just 2 pages, as states 2.
Any objection to states
We
2?
have no objection, Judge.
All right, states 2 is admitted. Mr. Thomas, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like that agreement is for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your